Are you in a shareholder showdown? Are you and your shareholders or founders in dispute, or do you want to avoid such disputes? At a city law firm, we are here to resolve disputes, but we're also here to plan carefully with robust legal frameworks and key documents to try and mitigate the risks of such disputes. And if they do arise, then we help you handle them efficiently. Whether it's a shareholders agreement or a director's service level agreement, the idea is to present you a solution to resolving these conflicts in the future, as well as preventing them. A well-drafted shareholders agreement is absolutely crucial. It gives clear expectations, provides mechanisms to resolve disputes. It's almost like a foundational document, a platform to build upon, setting out rights, responsibilities and obligations. So what are the key elements that we would include in a shareholders agreement? Well, we'd avoid a deadlock and actually put a mechanism in there, especially if there's going to be a 50-50 position for founders. We'll deal with your exit strategies, buyout clauses, and even contain restrictive covenants, which we deal with in later videos, because this is, again, to protect your business. What would we include in a service level agreement for directors, and what's the importance of these? Well, it outlines the terms and conditions of a director's employment. It clearly sets out their duties towards the company, gives performance expectations, sets out termination clauses, and again, if a conflict arises, what's the resolution? It can address bad faith actions, and how do you do that? Well, we try to look at the agreement and how to resolve them, and hopefully that agreement sets such provisions out. But if not, we're going to have to rely on general principles of company law. This is slightly protected, and it can often be difficult and complex. Unfortunately, this means legal costs and legal actions. So again, going back to the beginning, we're trying to mitigate that by giving you sound agreements. But if not, then we'd obviously look at exactly what's taken place and look at trying to find a resolution. Now that can be a legal battle, but ideally we want to negotiate. Even look at maybe mediation and arbitration. When founders fight, we really want to try and avoid this crisis, and the shareholders agreement is the best way to do that. In there, we'll have deadlock provisions, but the problem is a lot of shareholders agreements will actually be unclear. It might not give an exit process. It might not have any exit strategy set out. And worse, if that happens, then they're exposing you to competition, moving on to set up their own business or working with others. It is going to increase your legal costs. I'm not here to frighten you, but unfortunately, without a solid agreement, we are left with company rules and regulations, which are vague, costly and complex. We are here to negotiate and resolve that, but if I can say nothing more for businesses, to protect yourself, get a shareholders agreement, safeguard your business. By implementing this with service level agreements, you've actually just got clear provisions and clear objectives for both of you. As solicitors, we're here to listen, and that is my top tip for what you need over and above anything to resolve these disputes.